Good evening, ladies and gentlemen, friends and colleagues. Very nice to see you here this evening for this seminar on preparing for challenging times ahead, insolvency in the construction market. Now, for those of you lucky enough not to know me, I'm Renato Nazzini. I'm the Director of the Center of Construction Law and Dispute Resolution. And my job today is very, very limited, so I'm just chairing this event and facilitating what is going to be a very, very interesting discussion. Before moving on to the core business, I just wanted to kind of raise a question, which is why are we having this event today? I mean, don't we know, and have you not known for decades, that there are lots of insolvencies in the construction industry, and this is a big problem, and there are ways of dealing with it, and sometimes not. I mean, you look at the latest statistics, and Colin Johnson will really guide us through them and set the scene for this debate. But if you even look at the latest year, to the first quarter of 2022, the construction industry is yet again the first for insolvencies, more than 3,000, ahead of wholesale, ahead of the hospitality industry and accommodation, which of course is taking a big hit from COVID. So why this topic? Why now? I think there are two reasons, and one, if I may say so, it's a bit more on the pessimistic side, and one perhaps more on the optimistic side. Starting with being a little bit pessimistic, or perhaps realistic, it is fairly clear that the current climate and what has been going on in the past 2 or 3 years raises the risk of insolvencies in the sector, not only in the UK, but globally. And I'm not obviously talking just about COVID-19, but also the rising inflation, with what it means for raw material prices, and we have seen this in the industry already over the past couple of years. The geopolitical landscape, which is more and more complicated, more and more difficult, and again, I'm not talking just about the situation in the Ukraine. We are looking at currency fluctuations, more pronounced internationally, and of course, with projects being more and more international, including global supply chains and foreign contractors or subcontractors, this is going to be more and more of a problem. On the other hand, I think we can also today say that we have quite a bit of experience, unfortunately, in dealing with this problem in the UK and abroad. So certainly we have, or we should have, learned a lot of lessons from the past and from what has happened in the past few decades. And so clearly employers, contractors, subcontractors can better plan and be better prepared for dealing with this type of risk. And the courts, and dare I say the legislature as well, perhaps should look at these issues carefully, and when they are called upon to intervene, courts, arbitral tribunals, and there may be a case in the UK and elsewhere for targeted legislative reforms as well. Now, moving on to the core business of today, as I said, I mean, I have a very, very, very limited role, but those who will lead us through all these issues are the 4 panelists that you see on my left-hand side. And in the order of the program, I'll introduce them now so that we don't interrupt the flow of the discussion later on. And so first of all, talking about setting the scene in the current climate, is Colin Johnson, partner at HKA, with over 30 years experience, including acting as a lender, as an equity investor, as a developer, and a legal and financial advisor, and now as an expert, especially in accounting, financial matters, and quantum, and complex valuations, having acted as an expert witness on more than 50 occasions. And what really struck me is that he's not only fluent in English, as you would expect, and Spanish, but also proficient in Portuguese, French, and German. And anybody who has tried to tackle the Portuguese verbs will understand how impressive this is. Now, talking on identifying and mitigating risks is Emma Schaafsma, partner at CMS. Many of you know her. She's obviously in the disputes resolution team in London, but with huge international experience from Southeast Asia to China, from the Middle East to the United States, from Mexico to South America and New Zealand, in very many sectors, including energy infrastructure, gas terminal, wind, onshore and offshore, road and rail. Now, when it comes to managing the fallout, who can be better placed than Nicholas Gould, a partner at Fenwick Elliott, with a huge experience in both contentious matters and non-contentious matters, so he's really very well placed to look at these issues and deal with these issues when a crisis really arises. Among his very many achievements that you can see on the firm's website, the most important of them, of course, is being visiting professor at King's and having been with us on the MSc, making an important contribution for very many years. And last but not least, Alexander Nissen, QC, now head of chambers at Keating, after a very long career at the bar, which started in 1985, and he took Silk in 2006, and has acquired a huge experience in a variety of cases, acting for client developers, acting in PFI disputes, and importantly, for the topic he's going to address today, in many adjudication enforcement cases, because he's going to talk about the impact of Bresco when it comes to insolvency and adjudication. I would like to highlight that he was appointed as a recorder in 2007 and then a deputy High Court judge in 2013, and since 2015 he has been sitting regularly in the TCC. Now, moving on, starting with Colin Johnson on setting the scene. Colin. Thank you.
Thank you, Renato. And I do have the privilege of knowing Renato. Right, let me move straight into this and just actually look at some of the numbers. So here you'll see a backwards look, 2008 on the left. We had to put two different data sets together, which is why you'll see a line, but we think they are comparable in terms of overall insolvencies that were registered. Now this is England and Wales figures, but it gives you an idea, I think, on a broader basis as well, right through from 2008. Now, what you can see there is sort of ebbs and flows, if you like. It was creeping up until 2019, big drop in 2020, picks back up. 2022, that 5,201 is already on course to be amongst the top, if it continues for the rest of the year, is on course to be amongst the top years for a very long time in terms of insolvencies overall. And what you can see within those figures is actually that the lighter bar, if you like, is the construction percentage within that. So you'll see we start out 14 to 16% on the left. It then comes through 18, 19, 17, and this quarter 20% of the overall insolvencies. So that gives you a little bit of a feel for where we are overall. And if we look at those registered company insolvencies just for the construction sector, what you can actually see, same sort of trend overall, but actually for construction overall, if we carry on at the current rate, it will be a record breaker and higher than any of the prior years on this graph. Now, we don't know yet whether that will happen or not, but as we'll talk about as I go through, we certainly have some of the factors that could suggest that it will. So let's go through the last few years, and when we bear in mind these ups and downs, what was driving that? So 2009, we had seen that continuing upward trend since 2013 continue, and it was on the highest level since then, and the highest number of new underlying company insolvencies in the construction sector. So over 17,000 insolvencies overall, 3,200 in construction alone. And that was the sector that had seen the largest increase in terms of the underlying insolvency volumes, which was 2.2%, not huge, but going up through then. Then we get to 2020, and it's the exact opposite. You get the lowest level of insolvencies since 1989. When obviously so much was happening in terms of COVID, initially that may seem counterintuitive. But if we wind back, there were a few different things that were happening. First of all, basically, there wasn't only furlough and sort of the government mechanisms to actually support business. There was also reduced HMRC enforcement activity from the date of the first lockdown on the 23rd of March 2020. Now, bearing in mind that HMRC is one of the biggest, if not the biggest, actual drivers of insolvency filings, that in itself is significant. But beyond that, the government put other restrictions in place under the Corporate Insolvency and Government Act, and restrictions temporarily on the use of statutory demands and certain winding up petitions. So that again was a massive break in terms of the number of insolvencies. And that's why we see this big drop from 17,000 down to 12,600. And similarly in terms of construction, from 3,200 down to 2,000. Go forward into 2021, and it does start to pick up again, but still significantly lower than 2019. So we are seeing more voluntary liquidations. We are seeing the government measures ending, such as furlough, or being replaced with the tapering measures. And so that's what's starting to drive the change then coming through. And the three industries that had the highest number of insolvencies were construction, then wholesale and retail trade and repair of vehicles, and then accommodation and food services activities. So still very much key construction being a key part within the overall statistics. You did see a few that were actually showing a decrease, manufacturing, for example, but this trend sort of moving back up. And then we get to the last quarter that we have data for. So you can see already over 5,000 insolvencies for quarter one, and already over 1,000 in terms of construction. And I think the lack of some of the tapering measures, as well as what's happening in the wider economy, are what's driving that. And that perhaps leads me neatly to this. So we don't have the government supports. We clearly have the increasing costs, energy obviously, but it's also logistics costs themselves for transport, raw materials, labour. The pressures are broadly across the board. You have supply chains not actually functioning the way that they were doing. Part of it's Brexit, part of it's the pandemic, part of it as a result of some of those is actually restructuring of supply chains, and therefore new supply chains being put in place that maybe are not yet fully bedded in. We're now starting to see the interest rates head up and potentially, looking a little bit forward, shoot up, given the pressure that the Bank of England is coming under in terms of managing inflation. So all of those things together are why we can see some of the pressures that are going to likely lead to more insolvencies going forward. And sure enough, just a few quotes here from different parts of the press over the last few months. The number of construction firms in critical financial distress jumps 51%. That's this month, so that was quoted. End of April, number of firms in critical financial distress rises sharply. So this is why what my fellow panelists are going to talk about shortly in terms of what do you do about it and how do you try and prevent some of it is so important right now. And so just to round up, setting the scene, I've talked about the UK. This is looking then at a broader level across Europe, but there's still a 15% year-on-year increase that's applying. Some of the trends are a bit different in different places across Europe. The service industry was obviously a lot harder hit in several countries, so you will see that. But the point is that it isn't just a UK phenomenon, it's applying elsewhere. Fit that back in together with the supply chains and international supply chains, and even if the company you're looking at directly or your own company is fine, what about the people that they're dealing with? Who are they relying on to actually supply, whether it's labor and sort of people on site, whether it's specific materials that must be there, whether it's vessels, FPSOs, just looking in terms of all of those elements within the chain for any big construction project. These are the sort of things that we just have to take into account. And you will see the 5 factors, again from Allianz, just highlighting the global momentum of the economic rebound that's obviously going to be impacting the status of the fragile companies that have got high default risk. And obviously things like the war in Ukraine and new lockdowns in China have exacerbated that even more over the past couple of months. So overall, a scenario where we're already seeing potentially record insolvencies in the construction industry, but we have a lot of the ingredients that could mean it goes significantly higher than where it is even now. Thank you.
Thank you very much, Colin. And now Emma will talk to us about how to mitigate risks. Before she does that, please note down your questions. We are going to go through the presentations and then have questions at the end for all speakers. Emma.
Okay, thank you very much, Renato. So Colin has outlined for us what we understand to be the stresses in the industry and the pressures on supply chains. The next step then is to identify what the possible risk is to your particular project that you have underway. Understand the areas of exposure and what you could be doing at an early stage to mitigate that exposure. So that's what I'm going to be touching upon now. Now, regularly reviewing the financial status of your contract chain is going to be key to all of this. If you're undertaking regular credit checks, for example, of those in your contract chain below you, looking at a company's house reports and so forth, that's only going to get you so far. Either it only paints a partial picture, or it's simply providing you with old data. It doesn't tell you about the here and now. It doesn't tell you what's going to happen next week or in a fortnight's time or in a month's time. And that's what you're really going to be focused on. So the first thing really is to be thinking about spotting the warning signs as to impacts on your project. And certainly a lot of that is going to depend on active project management of those people who are on the ground. So an obvious one is going to be in terms of rumours that are circulating in the market. You could be talking with contemporaries who are working on, let's say, similar projects, who are working with similar supply chains. You might well hear gossip and snippets about pressures that are on particular companies. You may have grumbles on site by subcontractors or specific trades about how regularly they're being paid, late payment. You might even find that there's a thinning out of specialist trades on site. There may be issues with quality that are slowly creeping into works that you wouldn't otherwise be expecting. And that would suggest overtrading. So where a main contractor is trying to share specialist trades across as many sites as possible at the same time. Suspiciously inflated claims or applications for payment when there are no real grounds for doing so. I had a call the other day from a client who received a claim from a contractor for stolen materials amounting to about £50,000, and it was simply an extract from a spreadsheet. Now, contractually, the contractor certainly had no grounds for making that claim against my client. Contractor had care of the works on site and was responsible for site safety. Nonetheless, there was also no actual evidence that that there had been a reordering of the same materials. You'd expect to see additional invoices, let's say, for the same materials. So these are all indications that strains are appearing, contractors are asking for more money than they should. And it's vitally important that you keep on top of these claims and you address them immediately. If you're due to put in a pay less notice, you do so well on time. And of course, pleas for money on account. Asking for price increases without any contractual grounds, and claims that price increases generally in the market are amounting to force majeure. Certainly, if the global financial crisis has taught me anything, and I advised on a number of issues on projects, stressed contractors on projects, is that, and it may make me sound a little bit cynical, but these claims for additional money, these claims for force majeure because of the financial situation, these tend to come when the project is already at a critical stage. The contractor who's asking for money, or the supplier who's asking for money, knows that its supply or its works are going to be on the critical path or near critical path. You then, in turn, as the person who is faced with these claims for additional money, quite often your back is going to already be against the wall, because you may not have any alternative, or it may not seem as though you have any alternative but to meet the demands because of your responsibilities elsewhere and to other people. So with that in mind, it's very important to undertake regular project audits to understand what your exposure is on that particular project. You need to identify areas of potential weakness and the availability of options should you need them. So, most importantly, and it may sound trite, but which of your contractors or suppliers are critical to the project, not only in terms of specialist work or trades and specialist suppliers. Of course, the more specialist a supply, the harder it's going to be practically to replace them if they go insolvent. But most crucially, at what point is their work or supply going to be on the critical path of that project? How might you be able to mitigate against any delay to the project? What float do you have in the programme? Has any of it been eaten? Do you expect float to be taken up in the near future? to what extent would you be able to resequence the work or expect the contractor to resequence the work to deal with issues in supply? How easy, as I said, would it be able to find alternatives? Importantly, do you need to get approvals in order to swap out major OEMs, for example, or specialist trades? So either from the owner, the ultimate owner, funders. And if you do, it's important that you engage with them at an early stage, so that if you do ultimately need to engage an alternative contractor or supplier, that you would be able to avoid delays in getting those stakeholders on board. Even if you are able to identify alternatives that would be acceptable to the other stakeholders, you still need to do further due diligence in terms of who those alternative suppliers, contractors might be. Do you have an existing relationship with them? You might be able to leverage off previously a goodwill that's been built up to secure priority delivery slots, for example. What's their current capacity? What's their prices like? Everyone's prices are rising now. And where are they located? Are they located in an area where supply from there is going to be feasible and viable? There may be other residual risks that you need to consider, and in particular, in terms of warranties that are being given on the project. A incoming replacement contractor may be reluctant to warrant work that has been done before it, and if it does, there was probably going to be a price on that. You might be able to mitigate the risks of that by if you're able to get direct warranties from subcontractors and sub-suppliers. And so it's worth checking the contract terms to ensure if you already have a contractual right to that, and or the subcontracts, to the extent you have visibility of them, to ensure that those suppliers would be required to do so. Now, thinking about claims that you might have against an outgoing contractor, any claims that you might have against an insolvent contractor or supplier, let's say for delay LDs, for termination costs, for future defects, they're only going to be as good as the level of security that you hold from them. If you're left bringing your claims in an insolvency, you will be ranked below unsecured creditors, and even then would be subject to payment in the pound, which could be very low. So look at what retention monies you might hold. Is it cash or is it in a bond? If it's a bond, like all the other bonds that you might hold, advance payment bonds, performance bonds, are they on demand? Are there other conditions as to when they could be called? Are there conditions in the main contract between you and the contractor as to when you might be able to call on those bonds? Check those. You might have a parent company guarantee, which sounds wonderful, but do investigate the financial stability of the parent who has given the guarantee. Once you have all of that information, then of course you're going to be far better equipped to deal with a scenario where a contractor comes to you and says, please give me more money, otherwise I am at risk of failing and therefore causing huge issues in terms of timing and cost to your project. And essentially the decision then is largely a commercial one. You may well agree to provide further monies on account, even though there's no contractual basis to do so. But if you do, try and get a parent company guarantee to back that up. Ideally, you'd want a bond to back it up, but you may find that the banks are not willing to provide further bonds to their clients if they too are concerned about their financial situation. You may be asked to share the cost of increased prices, and you may well think that that actually is the better way forward. But if you do, it's important that you document the extent of the support that you're giving and for how long. Identify also whether, if the entity does become insolvent, what kind of discussions you might want to have with the insolvency practitioner in terms of keeping that contractor on board or the supplier on board and continuing to take supply from them. And that may well very much depend on the level of staff that are remaining there, their ability to keep on supplying, and so forth. Now, all that I've been talking about up until now is taking the view down the chain, and there'll be different considerations at play if you're concerned about the solvency of those up the chain from you. So, for example, a supplier concerned about the main contractor's solvency and so forth. And certainly the introduction by the Corporate Insolvency and Governance Act, otherwise known as SIGA, of something, Section 233B into the Insolvency Act, has changed the way that you might otherwise have advised a supplier before those changes came up. Now, I'm not going to talk in detail about the provisions of that Act and start citing them to you, but in broad terms, these new provisions will prevent a supplier terminating a contract because its client has entered into insolvency proceedings. So even though there is a termination provision for insolvency in the contract, they would not be able to exercise it if the client had already entered into insolvency proceedings. Now, there is the ability to petition court to allow you to nonetheless terminate if there would be supplier hardship. That test, I don't think, has yet been tested, but I'd be interested to hear if maybe Alexandra has had experience of that, or indeed any of the other panellists. And also, you would not, as a supplier, be able to make it a condition of future supply during the insolvency period that that the supplier is paid outstanding sums for supplies that were made before the customer became insolvent. And there is a tension there with rights of suspension that you might otherwise have under the Construction Act. And again, I'm not aware of that yet having been tested. So these are all things that you would need to consider very carefully. Thank you. Over to Nicholas.
Very much. And now, finally, Nicholas will take over to talk about how to manage the fallout and actually one of the players in capital, subcontractor, and supplier, anyway, that we have.
I'll have a go. Thank you. Thanks, Emma. Well, it's really nice, isn't it, to be out seeing real people again in 3D. I've been quite enjoying it recently. It's much better than webinars and so on, so it's great to see so many of you here this evening. Just sort of picking up from Colin at the beginning, you'll see that bump about 10 years ago where there was a lot of insolvencies, and I was just reflecting on a contractor that we dealt with then. A contractor came with unpaid claims, hadn't been paid for about 3 months, and of course you could suspend work, couldn't you, for non-payment of certificates, and that's the easy bit of the advice. But the contractor wasn't doing this because the developer didn't seem to have any money, and that they needed the project to get to a certain stage to persuade the bank to put some more money in. So that's why they were pushing ahead and getting themselves more into debt and not really paying their supply chain. Anyway, this didn't go particularly well because the developer got into difficulties and stopped trading. At this juncture, we went and spoke to the bank directly, and the bank was the Icelandic bank, who that week also became insolvent. I don't know if you remember this era, but it wasn't much fun. It wasn't much of a fun week, and that meant that the contractor at that point became insolvent. I'm not quite sure how much of the supply chain fell over. Anyway, as part of trying to rescue this, the last sort of step was to think, well, maybe we can find another investor, perhaps another bank or someone that might come in and take this development on, considering that everyone's swept away. The contractor was ready to sort of finish it, if possible, to try and get back some money. Anyway, after a few more weeks of trialling and error, we found that the project was worth about 42 million, 43 million, I think, when finished, and it wasn't finished, and 40 million had been invested at this point. And that was the end of really of that scheme. So it just goes to show, I think, how during good times people get very excited by projects, perhaps don't really look properly at the value of them or what might happen in the future, get deeply embedded in them, and then of course once you're building, once you're spending money, it's quite difficult to stop these things, and the project is going to be 2, 3, 4 years, isn't it, before you get to that point where actually you can sell it on or realise its value or see what it's really worth. Thank you very much. And of course all the time we're in times where inflation is low and investment values are rising, well actually even if the original investment didn't work properly on the spreadsheet, normally it's salvaged by the fact that 4 years later it's worth more than they thought it was going to be worth. So we're back to those times again, I think. So picking up then from what Emma was saying about looking for the signs, and I liked the rumours comment. I had a Fleetwood Mac moment. I don't know if anybody else did, but very briefly for some of you of that age. But rumours, it's one of the areas where actually it is really helpful. I do think rumours can be really quite helpful. And in law, they're not at all, are they? We ignore gossip completely. But this is one of the areas where going onto site and finding out what's going on is incredibly important. So that valuer who goes to site, whether it's the quantity surveyor or the employer's agent, whatever it might be, if they just scoot around the site once a month, don't talk to anybody, sure enough they'll value the works, but if they spend time talking to the people on the site, they're going to find out all sorts of interesting things about what's really happening. Now's the time to be doing that if you're in that role. So what should you do then if there is an insolvency? Well, act quickly. That's the first thing. I often think that this is one of the trapped in the headlights moments, because normally the team's never had this before. Unless they've been unlucky. So you have to act quickly, because the first thing to do is to check the contract. Has there been some sort of automatic determination under the contract, or do you need to take some steps? How broad is the definition of insolvency or the insolvency event under the contract? And we've been caught out by this over the years with JCT trying to keep up with the slight changes in what an insolvency event might be. Clause 851 of JCT, the design and build version, says that if the contractor is insolvent, so you have to determine that for yourself, the employer may at any time, by notice, terminate the contract. So you've got to be bold enough to take that step, but at least you can do it at any point. So often what we find on these distressed projects is we're waiting to the moment where we can see we've got a proper insolvency event. And usually the lead up to this is a very low labour level on site. One man and a dog is often what the term that's used, but you can see that nothing's been happening. And this, unfortunately, can go on for months and months until someone is brave enough to terminate. One thing you can also do with the termination, though, is include several other provisions and rely on other provisions in the contract. So if it were NEC, you might look at clause 91.2, substantially fails to comply with his obligations, so not building, not progressing, or there's the regularly and diligently in the JCT form. But we all know that is quite difficult to rely upon. But having said that, if the labour has dropped substantially and there's just no progress, you can. So you might want to rely upon both, but of course it's much better if you can identify a proper insolvency event. What about payment? Well, are you obliged to pay? Well, no, you're not obliged to pay until the works are completed, and then you can work out what the costs were. Can you use an alternative contractor? Well, the JCT provides for that, and it's sensible to have that in your contract. It's the only way to get it done anyway, but it's nice to have the express provision. Direct payments to the subcontractors. Well, maybe you can do that. It's rather dangerous, isn't it? If you were to do it, I think that the first thing you would want to be doing is to be able to reduce the amounts that are due to the contractor, which is a bit tricky. But you might have a term in the clause that in the contract at least allows you to. But you're still going to want an indemnity, I think, from the third party that you're paying, because you're probably going to fall foul of the pari passu rule in terms of once the insolvency practitioner comes along and starts to look at it. Secure the site is another important thing, because of course once the contractor's insolvent, they've got no obligations to do anything further, and you're going to need to secure the site, and the CDM regulations requires you to do that anyway. You might need to engage a health and safety firm to help you there. What's the state of the site? They're not always in the best state at this point, and you might need to take some steps to now make sure that it is safe. Security firm might be a good thing to hire. It's all very well locking the gates, but it might be very helpful to hire a security firm. And this is all part of protecting the works and the materials. I remember having a site where it was a warehouse. It was pretty well constructed. The roller shutter doors had just gone in, and there was a lot of M&E piping and apparatus inside. And so the way to secure everything was to shut the roller shutter doors. The contractor became insolvent. And the first thing that happened was the roller shutter door people turned up and took away the roller shutter doors, and then everybody else came and took away everything else, and it was just a shell suddenly. I remember talking to one of the people on site there, the site agent, and the question was asked about, well, what happened, when they came along. He said, well, a load of big guys turned up with a really big van, and he said, I wasn't going to stop them. Be my guest. So there's a bit of a reality difference between what happens and what you can actually do. Insuring the site. So once you've got an insolvent party, they cease to insure, and you need to check and see what's happening there. Suddenly, if you're the employer, well, you need to look at your insurance responsibilities and take steps to insure. Maybe you've got a joint names policy, but see what's happened to that. It may not be quite what you expect, and you will need to take steps to insure. The Contract Third Rights 2010 Act might help you get some benefit from existing insurances, but this is only something you're going to investigate if you've actually bothered to take the step of getting the certificates and getting the policies and so on. And often I find that people don't have these things, surprisingly. Security, Emma did mention check out the security that you've got, and this in the UK is going to be guarantees, isn't it? We're talking about guarantees rather than bonds. So bonds, on-demand bonds used internationally, but here we're talking about guarantees. And just to remind you of the difference, I always think of the difference being about 3 years, and some of you who have come to King's will know this. If you've got an on-demand bond, you can call on it, you're going to get the money. Pretty rare domestically. If you've got a guarantee, then it's subject to all those suretyship rules. It must be in writing and signed and so on, but you need to demonstrate and ascertain the loss that you have suffered. So this tends to mean that you've secured your site, you've thought about getting an alternative contractor in, you've tendered that process to make sure that you have got someone who is giving you a reasonable value for completing the works. They've come in, they've done it. You need to keep a track of variations and changes, because the original contractor would never have had to pay for those, would they? So you need to be able to separate those out so that when you do a notional final account of what the contractor who became insolvent would have cost to complete compared to the completion, you can see what you've really lost in terms of the additional costs and hassle factor. And that's when you've crystallised the amount that's due to you under the guarantee. So it could take some time. And I've seen situations where it's taken up to 7 or even 8 years to get to that point if the guarantor resists heavily. We have had a slight improvement in that area, and this is a case from 2020. You under a multiplex, and in that case, Justice Fraser decided that the decision of an adjudicator about amounts that were due was good enough in order for the bondsman to pay up again. So that's very helpful, because in the past we've often thought that really the only way to properly crystallise it if you've got a very difficult bondsman is to have the award or a court decision to make it clear. Of course, during negotiations, if it's obvious that they're going to have to pay out, well then they will come to a deal and move on. But it's not always in their interests, particularly if you're talking about high amounts. Collateral warranties were mentioned, and they're great if you've got them when time comes to sell on. But also step-in rights. I'm sticking with the position that I'm the employer and the contractor's become insolvent, because that's easy position to look at. So imagine you've got some step-in rights with your key subcontractors, assume you've actually bothered to get the warranties. Often we find that they haven't been put in place, but there we are. Same with the guarantees. The number of times people turn up with a guarantee that's not actually been executed or obtained. But imagine you have got step-in rights you can utilise. I mean, all the situations I've looked at, either for the employer or actually for banks and investors, we've never relied upon them in an insolvency event, because you have to pay all the claims that you don't really know about, you have to pay the unpaid amounts and pay going forward, which is of course fine. It's actually much easier for an investor to sit on their hands and let everyone leave site, not pay all that backlog, and then just get others to finish the job and try to do deals with the key subcontractors. Unfortunately, that is the way it always seems to go in my experience, and there's little that can be done about that. Plant and equipment. So I just want to look at plant, equipment, materials, and sort of finish on that. What can you keep on site? What do you have a right to? And I suppose the first thing to look at then is retention of title clauses. And some of you will remember the label of Remalpa from the Remalpa Aluminium 1976 case. It's a fun area. It's one of those that you never look at during the good times, and of course in the more difficult times you start to try to remember all these little cases about the issues that relate to retention of title. Just sort of quickly then looking through that, there is a difference between goods and supply of goods and services. So the Supply and Goods and Services Act 1979, in that act, title passes on delivery. So you have to ask yourself, who has got title. It is possible for the supplier to try and retain title, but if you've got a situation where the employer has paid the contractor's not paid the supplier because they're soaking up the money, eventually they become insolvent, then what do? Well, it might be the case that the employer has got good title if he's taken if he's paid in good faith and didn't know about a retention of title clause, and the JCT requires these types of clauses to be made known to the employer. So in that situation, the supplier shouldn't be removing their materials from site because title has passed. If it's supply and services, it's a little bit different. We're under the 1982 Act, and title passes when the parties intend it to pass. So assuming then that we've got a retention of title term in there, the main contractor's not going to get good title until they pay, so they can't pass it on, and that's a Dauber-Williamson case from 1979. The reality I find, though, is when you look at these things is they're not straightforward, because a typical shopping list of issues is going to be, well, is there a retention of title clause? Does the employer know about it? What does it actually say? What about materials on site? Have they been removed? Have you still got them there? Can anyone prove that they are theirs? I mean, if it's aggregate and sand and bricks, maybe not. It's not as easy as specific things, is it? And then, of course, if you're looking at the NEC, things are a bit different as well, because with option A, unfixed materials needs to be an activity. Option B, it needs to be in the method-related charges, and of course in the other options it needs to be a cost that's properly been included and paid for. The other question too is whether it's been fixed to the land, because once it becomes fixed to the land, well then title's passed, much like that roller shutter example where they came along and took it away anyway. There could also be competing clauses, and that gets you into more difficulty. So I think really then, just to try to sort of sum up some of these key issues that I've been having a look at, the first thing is to act quickly, secure the site, think about health and safety issues, think about insurance, and then take stock. Have the site valued, detailed records taken, photographs and so on, so that you've got a proper you can properly identify what is the state of the works, what is there, what materials are there. Start talking to the supply chain. And you're going to need a champion to do that. You're going to need your project manager or an additional team to really get heavily involved. It's very, very time consuming. Check to see what warranties and bonds you've got. Are they any good, or do you just file them and forget them? Can you call upon any of them? And don't forget, if you've got a good guarantee, what's the expiry date? It may be okay now, but when's it going to expire? Check that out and make sure you don't miss that date. Looking for a replacement contractor then is going to involve competitively tendering, so you can demonstrate value for money, and you're going to need that very detailed review of the works in order that the contractor knows what it is they're pricing and what it is they're completing. The hidden problem here is defects. It's pretty typical on these projects to find defects and issues and problems because during the latter phases of the project, quality's been running down, there hasn't been enough supervision, there hasn't been the management, things have just got done and usually not very well. And depending on the state of the project, the new contractor might have to rewind and carry out some additional works, putting things right. And no one will price that. That always ends up being done bit by bit, costing time and costing money. So don't forget then that's the real cost that you need to identify so that you can put it in the pot for the insolvency, but you're tracking betterment changes that you can't claim for. And then, of course, once you've got your notional final account, you'll be able to prove your loss in front of the insolvency practitioner. And Emma mentioned that you may not get much. The last one I think we did 3 pence in the pound. One before that, 5 pence in the pound. So, do you know, is it worth all of this hassle? Well, sometimes you just have to do it. So the real kind of problem is appreciating and realising just how difficult it is when this happens on a project, and wishing that you had put your PCG in place and your bond in place and all those sorts of things. So if you've got projects that are distressed, have a think about this list. If you've got projects that aren't distressed, well, go and check your bonds and insurance and stuff just in case. Thanks very much.
Thank you very much, Nicholas. And that leads us out naturally once again to examine Mr. Cusey's presentation on the interaction between the education review and the insolvency.
Yes, thank you, Renato. Yes, I've been asked to speak on the interaction between the statutory worlds of adjudication and insolvency, and particularly the impact of the Bresco case, Bresco Electrical Services and Michael J. Lonsdale. It's helpful at the beginning to remind ourselves of the statutory landscape. Section 108 of the Housing Grants Act provides that a party to a construction contract has the right to refer a dispute arising under a contract for adjudication. We all know that decisions of adjudicators are intended to have temporary finality. That is to say, it will bind the parties unless and until the dispute is finally determined by litigation, arbitration, or agreement. We also know that decisions of adjudicators are routinely summarily enforced by the courts unless the decision itself is invalidated by an excess of jurisdiction or breach of natural justice. Well, construction disputes are notorious for giving rise to cross-claims and set-offs. Generally speaking, it is difficult for a responding party to an adjudication to hold back a defensive set-off within an adjudication with the aim of relying upon it at the enforcement stage. The court's likely conclusion will be that it should have raised any such defence within the adjudication itself. Well, these set-offs acquire particular significance in the world of insolvency and are governed by Rule 1425 of the Insolvency Rules 2016. Materially, they provide this rule applies in a winding up where before the company goes into liquidation, there have been mutual dealings between the company and a creditor of the company, proving or claim to prove for a debt in the liquidation. An account must be taken of what is due from the company and the creditor to each other in respect of their mutual dealings, and the sums due from one must be set off against the sums due from the other. In essence, then, this account between debtor and creditor is taken for the purposes of identifying the net balance between them. And as Lord Justice Lewison explained in the John Doyle case, which I will come to in a moment, insolvency set-off is mandatory. It's not a matter of choice. Now, if there is no dispute As to the existence and the amount of the claim and the cross-claim, of course, that's just a matter of mathematics, A minus B. But if either the claim or the cross-claims, or both, are disputed, then they would have to be resolved by litigation or arbitration before the arithmetic takes place. So here we have the tension. The tension arises because of the immediacy of the temporarily binding decision of the adjudicator on a claim and cross-claim on the one hand, and the longer-term right provided by the insolvency rules to have a full and final determination of the cross-claim within the liquidation. Very early on in the history of adjudication, the Court of Appeal expressed the view that the latter right, the right to insolvency set-off, should prevail. And the case was Bouygues and Dahl-Jensen, 2000. And in that case, Lord Justice Chadwick said this: "In circumstances such as the present, where there are latent claims and cross-claims between the parties, one of which is in liquidation, it seems to me that there is a compelling reason to refuse summary judgment on a claim arising out of an adjudication, which is necessarily provisional. All claims and cross-claims should be resolved in the liquidation, in which a full account can be taken and a balance struck." And that is what the insolvency rules required. And he said, "It seems to me that those matters ought to have been considered on the application for summary judgment." Now, in Bresco, it was argued that a party in liquidation was, for jurisdictional reasons, not entitled to pursue a claim in adjudication in the first place, despite Section 108 giving that right to a party to a construction contract. The argument was that because of the automatic insolvency set-off and cross-claim regime, that was not a regime which was applicable under the contract. And therefore the adjudication contractual right had ceased to exist and was replaced by the statutory claim to the net balance. That argument was rejected by the Supreme Court, who made clear that from a jurisdictional perspective, a party in liquidation is still entitled to commence an adjudication, even where the responding party has cross-claims and set-offs. The scope of the adjudication regime in Section 108 was wide enough to encompass such claims. Lord Briggs said, "Returning to the main submission, the existence of a cross-claim operating by way of insolvency set-off does not mean that the underlying disputes about the company's claim under the construction contract, and if disputed the cross-claim, simply melt away so as to render them incapable of adjudication. The submission that they are replaced by a dispute in the insolvency is wrong." And the court was at pains to point out that it would not restrain by injunction either the issue or the continuance of such an adjudication. But if the decision in favour of the insolvent claimant is unlikely ever to be enforced, what on earth is the point of it? Well, strictly, Bresco was a case about jurisdiction, not about enforcement. Indeed, Lord Briggs was at pains to point out that all of these questions about enforcement should be raised then and not at the initial stage of the commencement of the adjudication. He went on to make some obiter dicta observations about the utility of adjudication, suggesting that an adjudication commenced by an insolvent party would still have its uses, as there were some circumstances in which the decision may be enforced. The best example of that would be where the cross-claim would, on any view, not overtop the claim. My own experience, and I'm sure many in this room, is that parties facing insolvent claimants always manage, surprisingly, to find cross-claims that overtop the claim. But I have to accept as a matter of theory that that may not always be the case. In the more routine situation, the decision, Lord Briggs suggested, may have some form of value as an ADR event, even if it is not itself enforceable. Since Bresco, the Court of Appeal has looked at this question in the case of John Doyle Construction and Erith Contractors. Much of the case was concerned with the question of what security would have to be provided by a liquidator seeking to enforce an adjudicator's decision. As you will know, following the case of Wimbledon and Vago, courts tend to award a stay of execution in respect of an adjudicator's decision, where it is unlikely that the successful referring party will ever be in a position to repay the adjudicator's decision if it turns out at trial to have been wrongly granted or too high an amount. In Meadowside and Hill Street, the TCC deputy judge determined that a suitable form of security could be ordered to avoid this difficulty. And if it was, then summary enforcement of the adjudicator's decision would be given without a stay of execution. However, in John Doyle, the Court of Appeal made clear that such security would have to be clearly evidenced, unambiguous and sufficient for all the circumstances. And it's clear that the mood music was that it will be very difficult to offer sufficient security that would be acceptable to the court. One also assumes that the commercial market was unlikely to offer sufficiently attractive terms to liquidators that they would find acceptable. The Court of Appeal was pretty dismissive also of requiring the sum to be paid into court by way of security. Whilst Lord Justice Coulson said it was in theory a proper way to provide security, he went on to say that payments into court were the worst of all possible worlds because they were contrary to the philosophy of cash flow for which adjudication had originally been introduced, and would starve the main contractor of money, and the money would simply be sitting in the court's account. He ended by saying that if payment into court was a proper method of security, about which I expressed no concluded view, it seems to me that it would be regarded as very much a last resort. So one of the take-homes from the John Doyle case was that although there were no jurisdictional objections to liquidators starting adjudications, absent adequate, clear and comprehensive security, the decision was unlikely to be summarily enforced without a stay. What has interested commentators most were the obiter dicta comments from the Court of Appeal, which considered what would have been the position if sufficient security had been provided in that case. And there are clear tensions between the dicta of Lord Briggs in Bresco in the Supreme Court and Lord Justice Coulson speaking for the court in John Doyle. However, in seeking to reconcile those tensions, Lord Justice Coulson said, I do not believe that Lord Briggs was saying in his obiter observations about enforcement that a company in liquidation was entitled to enter judgment, let alone recover the monies that were the subject of that judgment, on the basis of a provisional decision in circumstances where there was a continuing set-off and cross-claim. He did not suggest that there was any right to enforce a claim which did not take into account the set-off and cross-claim. On the contrary, he expressly approved MS Fashions and Stein and Blake. Neither was he saying that, contrary to what Lord Justice Chadwick said in Bouygues, summary judgment should be granted and enforced on a claim arising out of adjudication, which is necessarily provisional. On the contrary, he expressly approved what Lord Justice Chadwick had said in Bouygues. Lord Justice Coulson explained that since the adjudicator had not been given the power to finally decide, as opposed to provisionally decide, the net balance, Erith continued to retain its set-off and counterclaim in the insolvency. On that basis, there was no entitlement to summary judgment on the amount provisionally found to be due. Well, if you cannot get summary enforcement on a final account dispute that was referred to adjudication, it's obvious that the chances of doing so in respect of any adjudication on an interim payment are even more slender. At first instance in the John Doyle case, Mr. Justice Fraser had said that rarely, if ever, to use his words, would a claim based on a failure to have served requisite payment notices ever be enforced by the courts. So if the refusal of summary judgment is the likely outcome, once again, we must revisit the question, what is the point of a liquidator starting an adjudication in those circumstances? Well, I want to explore 3 points made by Lord Justice Coulson in this context. I've broken them down into 3 separate subparagraphs. He said this: having commenced enforcement proceedings, an insolvent claimant can then get the defendant to put up or shut up. First, it can make the same larger claim in the litigation that it made in the adjudication, even if it makes plain that it would accept the adjudicator's lower figures, thereby putting the defendant at risk of paying indemnity costs from the outset. Second, it may be possible for the claimant to demonstrate an entitlement to an interim payment under CPR Part 25. And thirdly, the fact that the adjudicator has apparently considered the claims and found in the claimant's favour will put the defendant on the back foot throughout. Robust case management would lead to an efficient resolution of the remaining areas of dispute. Well, how realistic are these 3 things? First, he suggests that the adjudication would have been worthwhile because a liquidator could then issue legal proceedings claiming the higher figure, but offering by way of Part 36 to accept the adjudication amount. Well, that strikes me as a pretty expensive way of calculating the basis for a Part 36 offer. Surely the liquidator would make his own assessment for the purposes of Part 36 without having gone through the process of obtaining an unenforceable adjudication decision. Moreover, Part 36 is not available in arbitration. The second reason given would be the facility potentially to use the interim payment machinery in CPR 25. This has not yet been tried, and I'll be very interested to see if it could be done. There are, I consider, 2 real difficulties with it. First, it is only available in litigation, not arbitration. Second, it will be very difficult, in my view, to persuade a court that simply because an adjudicator has decided in his favour, to quote CPR 25, if the claim went to trial, the claimant would obtain judgment for a substantial amount of money against the defendant. As the Supreme Court made clear in Aspect and Higgins, the adjudicator's reasoning has no legal or evidential weight. Lord Justice Lewison made that point himself in John Doyle. Courts readily understand that adjudicators' decisions are made within very short timescales and may be prone to errors of fact and law. We've seen plenty of those. In those circumstances, it cannot be said that the adjudicator's decision provides any basis for saying that at full trial the claimant would obtain judgment for a substantial amount of money. Well, then the third reason given by Lord Justice Coulson suggests that an adjudicator's decision will put the defendant on the back foot, and that a claimant with the benefit of one could seek robust case management from the court. Again, it will be interesting to see if the TCC develops this thinking. My expectation is that the claims brought by liquidators will be treated no differently from any others, even if they already have an adjudicator's decision under their belt. The last matter I want to explore is the compulsory adjudication provision. In John Doyle, adjudication was a precursor or necessary first step in the dispute resolution process. If a company is in liquidation, a liquidator or other representative may have no option but to pursue adjudication, even if he knows that the decision will not be enforced. That is because it is the only way to advance the claim, which would then go for final determination. The cost of doing that may itself be a deterrent which precludes the advancement of the underlying claim. I question whether contract draftsmen might consider creating a contractual exception to this precursor step, which allows for it not to be taken if a party is in liquidation. Then consider the effect of a provision which requires a notice of dissatisfaction with an adjudicator's decision to be given within a fixed time, failing which the adjudicator's decision becomes binding. This, as it happened, also occurred in John Doyle, and a very interesting dynamic it was too. Erith, the main contractor, had issued a notice of dissatisfaction, which stopped the adjudicator's decision becoming a final determination, but even years later had never commenced litigation proceedings for that final determination to be undertaken by the court. Conversely, John Doyle, as the successful referring party, had not issued a notice of dissatisfaction because it was content with the decision. However, having failed in the ability to get summary enforcement of the adjudicator's decision, and not having issued its own notice of dissatisfaction, the question arose whether John Doyle was entitled to start litigation to pursue the final determination. Well, at least two people in this room know that that particular case has settled, and I'm one of them. So we won't get an answer to that interesting question. So some concluding thoughts. It is now clear that jurisdictionally, companies in liquidation may bring claims in adjudication. However, the circumstances in which summary enforcement will be permitted are likely to be rare. Will those authorities deter liquidators from using adjudication? Our two highest courts have debated whether adjudications of this type serve a useful function at all. The prevailing view of the commentators seems to be that in practice liquidators or funders will not now use adjudication because any favourable decision will not get enforced or will be subject to a stay unless suitable terms are offered. This suggests that for all the legal discussion in the courts about the utility of adjudication, the insolvency market itself is not attracted by the deal with which it has been left. However, there may be cases when an adjudication has to be commenced, despite the unenforceability of the outcome, simply because it is what the contract requires. Either that or the liquidator must abandon the substantive claim completely. Lastly, as I indicated through the content on the slide, I'm sceptical about some of the supposed benefits of adjudication to a company in liquidation suggested by Lord Justice Coulson. However, it remains to be seen whether either a liquidator or funder is prepared to take a chance and try them out. Similarly, it'll be interesting to see if responding parties feel they have to contest such adjudications for fear that it may give the insolvent party the so-called advantages identified by Lord Justice Coulson. Thank you very much.
Thank you very much for this very interesting comments on Bresco and John Gould. One thought about this case is that adjudication was certainly first and foremost about cash flow and preventing insolvencies. So really, what's the point of adjudicating for an insolvent company? Now, it's true, as Lord Briggs said in Bresco, that adjudication is much more than that now. Perhaps since the very beginning, it is an issue resolution method. It's a right that very often results in suit, but doesn't seem to be the case in these circumstances. And one wonders whether next time the government will have time to look at the Construction Act. This is perhaps an area which could benefit for some technical clarification. Now we have the 4 drinks. We have a bit of time for questions. So I wonder whether there is anything from the audience. Yes, at the back over there, and then we do have microphones. The microphones are there. And the gentleman is very back there. Anyone more questions in the meantime. Yes.
Hi, good evening. Very interesting presentation. In the United Kingdom, we've got quite a straightforward defined insolvency process. Most people know priorities, since the abolishment of debtors' prisons long ago. It's not very scary thing in insolvency. How about the Middle East? The very different laws and jail debt, bank trips, etc.
Oh, brief. Yes, it's not a place to become insolvent, is it, really? For those of you that might not appreciate this. Yes, they still do have an old-fashioned approach to that. They did introduce an insolvency rule when I was running the office in Dubai, but no one ever seemed brave enough to use them. I think a lot of it depends on who it is you owe money to, actually, Sean. Because I know there are certainly people that have now managed to quite leave because they owe far too much. So yes, whilst certainly Dubai in particular has offered great golden opportunities to many, if you find yourself in debt, you might spend more than you thought. Having said that, I mean, you mentioned about insolvency becoming reasonably clear. It is quite complicated, and SIGA has made it a bit more complicated, so there's still plenty of rules to be worked out.
One thing to say that actually this international dimension is particularly interesting because obviously I come to this more than an arbitration lawyer, an arbitrator, and of course you see it very often when companies go, unfortunately often companies going into insolvency, receivership, etc. And then it's not just enough of the English rules and UK law, but you may be facing Middle East or Latin America, any Asian country or any African country you name, and it is quite tricky because in some legal systems, of course, it's quite established that arbitration can proceed. In some legal systems, arbitration can proceed only with the consent of the liquidator or the court. Obviously, if you are acting as counsel, then you have now to take instruction from the liquidator rather than from the client, with the complexities, the delays, the time extension that you have to ask the tribunal to grant. They are generally granted, and then you are caught between these two problems, the tribunal and your opponent on one side and the insolvency court on the other, which in some countries actually takes quite an active role in managing ongoing proceedings. Now, having said all that, we will have a very interesting session in November at our 35th anniversary conference on insolvency and arbitration in common law and civil law systems. And from your experience, I think you are also an experienced counsel internationally.
No, indeed. And actually, what you said struck a chord with. There were a couple of instances around about 5 years ago where I was advising Japanese entities who were purchasing supply from South Korea, and from working with local Korean council, it fast became clear that they had their insolvency legislation provided for really the equivalent of Chapter 11 under the American rules, and that therefore severely constrained the options that were available to our clients as to what they could do. I had another instance where we were acting for an employer who was building a direct iron facility in Bahrain, and there was a continental European contractor who, and this was during the global financial crisis, one of the ones I was thinking about when I was jotting notes down for today, And when you get into that kind of situation, what Nicholas was saying as well, on these overseas projects, you can sometimes feel as though you're battling in the Wild Wild West and you really need your wits about you. So the contractor in that instance came to the client demanding additional monies, and it was all on the premise of force majeure, which obviously wasn't going to work. And they said, you don't pay us, we're walking off site, which was one threat. While the client was working out what its options were, they got a phone call from the site, and not only was that contractor demobilising, but it was also starting to dismantle the work that it had actually already executed and the plant that it had already installed. So then we had to quickly ring up the guards to stop them from taking stuff on site. So it's nothing is neatly packaged in within the boundaries of what you're taught in a textbook or anything like that. You've just got to work it out, and you've got to, as Nick said, you've got to react quickly.
Colin, just a couple of things in terms of picking those up. As you said, you've got to react quickly, you've got to actually work out partly where the position is. So, firstly, picking up Nick's point, in terms of the Middle East, we've certainly seen a couple of major contractor insolvencies. So it's not as if it's not there at all, but it's certainly difficult and complicated. And then what we've actually found is you still have some of the same things that you would apply elsewhere. So we've had to actually look at, well, what would the value be to complete that portfolio of projects? Nick gave the example of a project worth 42 million and they spent 40. And it's exactly that sort of situation that you have to work out quickly. Is this worth spending money on? Is it not worth spending money on? How do we sell it now? What's the true fair valuation? And actually getting in from that early on.
Thank you. And obviously, this is just, without even starting talking about the different kinds of insolvency proceedings that there are around in all these different jurisdictions. You have creditor arrangements, voluntary arrangements, special administration, insolvency proper, which is like the end of the company, so on, with different rules. Any more questions? Yeah, obviously very frank.
Shall I try and talk up? Yeah. Clearly rather than predicting. So, and Renato, picking up on your point there and sticking with the international flavour, in the UK, we have an insolvency system. Once a company is in any sort of formal insolvency, it's the end of that company. And on a construction project, it's absolutely catastrophic. And what I've seen recently is on an insolvency that covered other jurisdictions across Europe. It's a very different approach. And, here we go. A different approach in other European jurisdictions, which offer far more protection to companies than we do in the UK. There's a moratorium, and there's actually a genuine intention to try and see if there's a way of salvaging that company and it trading its way out, and in some instances that is for the best interest of a project and all parties concerned. I suppose my point is the panel think it's time for change in the UK and a relook at administration which has laudable aims but never ever, in my experience, results in a genuine turnaround of fortunes again.
I suppose SIGA was mentioned, this corporate insolvency and governance act 2020, which we're all thinking about it. And the thing to remember about is it was already around before COVID, but we only really remember it because of COVID. So there were some permanent changes that were about to happen, and they introduced some temporary ones. Those ones that we remember changes to winding up orders and restrictions and so on. But one of the permanent measures was this new introduction of restructuring plan, which is a bit like Chapter 11. So I don't really remember about it to talk about it properly, but that is more towards what you're saying. And whilst that might provide more fluid solutions to problems, it gives us great difficulty in knowing what to do front end when drafting and quite how to deal with it. But I think we're going to see more of this probably at the moment, certainly I've got quite a few distressed projects at the moment. And
as we go to energy.
Just to bring out one point, which is completely understand where you're coming from. The challenge is every time you move that, you also move the goalposts for the financiers, and therefore their willingness to lend becomes less and less the less protections they have. And so actually, you know, it would be a study in itself, I think, of is it actually worth giving the corporates better protection and losing some of the lending to the sector? And I don't know, or I don't know the answer to that question.
So just one more thing. And the other thing is that the more flexibility there is. I mean, what are we really saying? We're saying that we should find money to keep the supply chain going, even though the person that is championing the project already sees it now as something that just that's a lot to lead on. But that's the reality, is where does the equity come from in a project that's not going so well? And I'm afraid of one other stories coming to mind. I'm feeling a bit like Ronnie Corbett, basically. But I had a project where the contractor became insolvent about halfway through, maybe a little bit further than that, and this was office development, several offices out of town. And the buildings were structured there, the roof was all on, but there was a sort of top-down kind of situation with all the windows in. All the windows roaming in double places, all being delivered, purpose-made for that project. Now the supplier had not been paid. And so it's all very well, you know, having a retention of time claim on those, whatever, but they only fit that building. And so by the time we repackaged this, and then the next contractor came on board, basically the subcontractor ended up signing up at 80% of their original contract. There was nothing in it for them, at least they were salvaging. They installed all of those, and when the project was about 90% complete, that second contractor became insolvent too. So as did the window contractor, because they never got paid a penny. And you know, just pausing there, what were those buildings really worth at that point in time? And where had the money actually gone? So you know, I think those buildings actually were mothballed for some years until the economy improved and someone had some money out of them. But certainly not construction.
Just to conclude this point, because I have experience in jurisdictions where you do indeed have this restructuring procedures, etc., very much aimed at rescuing the company. But I generally work in sectors, for example, such as manufacturing, where you can, or other sectors where you can, for instance, release the equity from assets. So sell part of the company, sell assets and make money and then keep growing. Or they work where the government is prepared to put money into a company, etc. In the construction sector, where very much the company is financed by banks, lenders, and cash flow, and there is very little to sell or equity to release, I can't really see it working very well, actually, as I think Colin made to that kind of, let's say, restructuring or rescuing procedures. Well, is there one more question there? I have a question, I think for Emma and Nick, actually. We were both kind of going there in different ways. And it is about what happens on a project which is ongoing when there are warning signs, there are issues, and you can see that. You know, I think one is not very many people on site, and you know, we start having delays and etc. that are, you know, potentially have to do with a kind of pre-insolvency situation. Now, I think what came up is you pay, I think it's you pay the supply chain, and that has seen that happen. You pay the suppliers directly, or you pay the subcontractors directly, and then deduct that from the income payment certificate, with agreement, obviously,
After the insolvency.
No, during. Or after, or in a period where the contractor is in distress, right? So, you know, we are facing financial problems, and then you pay the supplier, you pay the subcontractor, you pay the subcontractors, and then you agree with the part of the contractor in distress where this money will be deducted from your interim payment certificate, etc., and the final. And the other option that you have, and you have it in very many contracts, including physics, I mean, it's an option of this scope. Okay, you know, I take this out of your scope and I ask someone else to do it. And the problem that you have, of course, is that someone else may do it at a high price, and then you may have a claim for a difference. You might have to scope because you were not quite able to do it, then I paid more. And so, in your experience, I mean, these two options, I mean, how do you see them? Do they work well or not? Is there a better one depending on the circumstances? And then do you want to go?
Yeah, I mean, I guess let me first take the payment, the direct payment to subcontractors. I would always be extremely cautious about going down that route, and that is particularly because if the main contractor does become insolvent, the risk of the administrator clawing back those payments as preference payments could be high, and so that's going to be an issue for you. On an international scene, you may actually find that it's just simply not permitted under the local law that might infringe on your contract, notwithstanding that, for example, it's governed by English law. So I wouldn't treat that as an easy option. I think in terms of other steps that you could take, things like de-scoping, I think there the answer very much lies in the contract. I mean, certainly you do have the option under, let's say, FIDIC to de-scope and review omitted works, but there is a provision in there that then the contractor will be compensated to an extent that it wouldn't be able to earn a profit on the works that are being de-scoped. You would simply be able to take work out of their scope willy-nilly. That would incur a penalty. And I think you need to be very careful if the contractor or a subcontractor, which we're looking at down the train, if you are concerned about rates of progress, about their solvency, about what's happening on a day-to-day basis, you've got to be very careful that you are not going to take steps that are not sanctioned by the contract and therefore would put you in breach of the contract yourself. So, take care that you are actually allowed to de-scope without penalty, for example. Be careful about, as Nick was explaining, it may not be clear that the contractor is actually insolvent. You may have your suspicions, but it may not be absolutely clear. And unless you know that termination right, which is a contractual right, has actually crystallised, you could be actually causing yourself, a huge amount of problems being in the repudiatory breach yourself. So you just have to be very careful about the steps that you take. You don't want to be too compelled. I don't know if you've got anything to add to that.
Well, certainly I would, my experience of these direct arrangements is, as you've said, they're really complicated and almost never work. There's two separate things. One is the question of whether you enter in the main contractor is carved out, so to speak, so there's a direct new contract between the original subcontractor and the employer. And the second is making payments that subcontracts can exist when you make payments under it. And they both have real problems. And certainly my experience is that these situations often arise in two cases. One is where the subcontractor is someone who was brought to the piece by the client in the first place because they had some particular product, especially whatever it may be that the employer liked. And and so the main contractor never really liked them in the first place. So you've got a bit of a battle there. And the second similar problem is that you have a debate of some kind, delay usually, running sore between the main contractor and subcontractor, which means that if you take on some direct arrangement with the subcontractor, you're entering into a dispute over which you as client have no control. So it tends to be really difficult, I think. By definition, I never see things that work, but it's poison.
Yeah. Any more questions from the audience? Any final comments from the panel?
The only thing I would just add, which we haven't touched on at all, is injunctive relief from the court. Don't forget, particularly with retention of title issues and things like that, the courts, and particularly the commercial court and the TCC, will readily make time available for suitably urgent cases to injunct people to deliver up things that should be restored separately that belong to you, all those type of things, or trespass cases, or whatever they may be. It's well equipped to deal with those sorts of things, and they often do crop up in these difficult times, and also they're worth thinking about.
Well, then one last thing for me, before inviting you to drink just across in the arcade, is to ask you to join me in thanking our speakers in usual way. Thank you very much.